almost without fail, either at the first interview or sometime as we start developing the case, I'll get the question from my client, how long is this all going to take? When is this going to be behind me? And I unfortunately have to say, I don't know. It depends. But I can give them parameters of where decisions will need to be made and how they affect the timing of a case. And it goes like this. First thing we do is gather medical records and evidence of liability and get comfortable with exactly what the client's injuries are and what the fault of the defendant is. And once we have done that, we simply track the plaintiff through their medical care. Until he or she has told us, I'm done treating, we just follow on with them and track with them, keep the insurance company abreast so that they can put proper reserves on the case of the client's injuries. And once that client tells us, gee, my doctor released me last week and says I can go back to work full-time now and I don't need to come back anymore, then we write the doctor's office, get the final medical records, ask the client to give normal daily and weekly and monthly activities a chance to kick in for a month or so to make sure that the return to full-blown pre-accident activities doesn't cause any recurrences and the like. And while they're doing that, we're putting together a demand package, and that demand package will include all the medical records associated with the accident, will include frequently photographs of injuries, will include photographs of the accident scene if applicable, and will include other pertinent types of information that may help the insurance company understand the full range and extent of our client's injuries. That process takes 30 to 60 days from the conclusion of medical treatment. We send that in, and usually there's a period of 30 to 90 days in which we try and get the case settled with the insurance company. And if that is successful, then the case is over at that point. If it's not successful, sometimes we will engage in a mediation process. Other times, depending on how long it's been, it may be necessary to file suit to protect the statute of limitations, or the insurance company has refused mediation and litigation is the only avenue. And what we tell most clients is that virtually all courts adhere to the Supreme Court of Virginia's requirement of its local courts that 90% of all cases be resolved within 1 year of filing. That's the standard in Virginia. And we find that from Fairfax County, that has 25,000 cases per year filed in it and 18 or 19 judges there, to little counties like Bath County down in near Roanoke that has far fewer, that almost all Virginia courts adhere to that standard. And so if the case should be litigated and should go to trial, that process from filing to trial is usually a little less than a year. If there's an appeal, that appeal process can take a year. If that appeal process sends the case back to be tried again, add another year. So the litigation process, if things go in the least efficient way and the most litigated way, can sometimes be as much as 3 years or more from the time you file. That's unusual. Most cases are resolved within, I would say, 4 to 10 months after the client concludes treatment.